Hi everyone, thanks for joining me today. We're diving into one of the most unbelievable cases I've ever come across. In this one, Judge Washington doesn't hold back when dealing with a so-called sovereign citizen who's clearly out of line.
You should seek some mental help. There's
I'm
something
sorry?
wrong with you. You have
You
a
said
mental
what?
you have a mental problem.
I
If
have
you
a
think
mental
the
problem.
laws
How?
in the United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it.
Not long ago, I talked about this woman who caused quite a scene, with her kids yelling in the background the whole time. Well, this time the kids are at school, and now it's her mom who's about to get a lesson, straight from Judge Washington. Let's jump in.
Good morning. The 14B District Court is now in session. My name is Elaine Washington. And
I find everyone's pain funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anise Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anise Battle, appearing especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking, please.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law
Please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
Well,
not.
that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
Someone sounds like a sovereign citizen and acts like one. Well, you get the idea. In the last video, I mentioned that her main defense is something called constructive eviction. That's when a landlord lets a place become so unlivable that a tenant can legally break the lease. But here's the catch. She gave up that right by continuing to live there. So that argument doesn't hold up. Still, she's sticking to her story.
Whatever you're using as your basis is still not correct. It is not the law.
It is. It's still under
Not
MCL and it's under the Landlord-Tenant Act.
overruled.
My objection is overruled, Your Honor.
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because
rescinded?
that's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to
Ma'am,
asking these
please
questions.
move
I will
on.
continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You studied a statute that I actually need to look up. MCL, what
I'm sorry.
was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
I always get a kick out of it when they try to quote the law, because in this case, the lawyer actually gets it right. According to Michigan law, specifically MCL 600-5716, the property manager has to file a demand for possession before the landlord can start the eviction process. So not only is she confused about how it works, but it seems like she didn't bother to read the law properly either.
Have you read that statute?
Yes, I have read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop talking. It says, a demand for possession or payment shall be in writing, addressed to the person in possession, and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there proof of service of it on the record?
That's a different question, though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession,
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's now, again, she's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay, that's fine. I didn't cite an exact statute, but I appreciate your objection.
Don't let this be a reminder. Don't do drugs, folks. They seem to mess with your memory, like forgetting what you said less than 2 minutes ago. So, let's take a quick look back and jog our memory.
What's the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716. I just said MCL because they're both under NCLs. Both proof of service and certificate of service are both under MCL.
No.
All right, well, everybody,
You,
let's not make my ruling.
let's just, okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
Okay,
is
ask that question.
not on the disposition. And just like she read on 657.16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
object to it, I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next question.
And she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you objected me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear.
Just
I said either federally funded or get federal funds, which you do if you accept Section 8 and vouchers.
Case. Next voice. Oh, you're absolutely getting a fair hearing. You just don't want to accept that you're wrong. And honestly, it's not the court's job to reward confusion or misunderstanding with free rent for life, especially at the landlord's expense.
No, that's not true.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are, do you?
I'm not saying that. I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that these are the requirements. Hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing here.
Oh. Wow. It's not every day you see a judge lay it all out like this. She lets her know that criminal charges could be on the way for pulling the usual sovereign citizen routine and clogging up federal courts with bogus filings and fake liens. And because you know my team and I always go the extra mile to give you the full picture, I've got a little surprise for you at the end of this video.
Move on.
Move on. So, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the property.
The court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If I cannot have, this is not a fair hearing. And again, this is why
you're trying to turn this into
I'm not trying to turn it into anything. I'm just trying to state the laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not, and I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
please move
all
on.
this is not right. And Attorney
I'm going to be filing criminal proceedings against you for all these frivolous things that you're filing against me.
Of course you do. This probably isn't your first time trying to scam your way into free rent. And now you're talking about the marshals getting involved. Hate to break it to you, but it's not going to be the marshals. It'll be the sheriff's department, and they'll be there to remove you so the property can be reclaimed. At this point, Judge Washington's patience runs out, and she finally lets her know exactly how she feels.
You feel that it's frivolous, that's fine, but it's not. My rights are not frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute as
cross-examination.
If you're not going to ask appropriate questions, then I'm just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't have a real opportunity to ask the questions. So at this point, like I said, I'm just going to have to get the federal court involved and get the marshals, because I don't know what you all are going to do. Oh.
Even if no one challenges it, a frivolous motion is still baseless and has no legal standing. So whether you agree or not, that's exactly how the court sees it.
You all have
I
not
know
been
some people
acting
might say the judge should
in
handle things
honor and
differently,
with good faith.
but the
So
truth
I don't
is,
know.
she knows exactly
I'm
what she's
stuck
doing.
on what to do. The
This is her way of
integrity of the court's
encouraging the
question.
attorney to ask for a directed verdict.
I don't know what that is, but you should seek some mental help because something's
sorry?
wrong with you. You have
You
a
said
mental
what?
You have a mental problem.
I
If
have
you
a
think
mental
the
problem.
laws in
How?
the United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific. No, be specific because
No.
now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right. I have
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action. And I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not a